Hello everyone, and welcome to Uncivil Law. For today's case, we have a case from the Supreme Court of the state of Mississippi. This is the case of Willie Nash versus state of Mississippi. In this case, Mr. Nash was found with a cell phone while in jail. This got him an additional 12 years of prison time. He's appealing on the basis that this was disproportionate sentence for the violation. So we're going to read a little bit more about what happened in this circumstance and try to see what is happening and why, and let's get started with this. A jury found Willie Nash guilty of possession of a cell phone in a correctional facility. Nash does not appeal the jury's verdict. He only challenges the sentence, 12 years in prison. He claims the 12-year sentence is grossly disproportionate to the crime and thus violates the Eighth Amendment. Though harsh, Nash's sentence falls within the statutory range of 3 to 15 years. And the judge based his sentencing decision on the seriousness of Nash's crime and evidence of Nash's criminal history. Because Nash has not shown a threshold comparison of the crime committed to the sentence imposed leads to an inference of gross disproportionality, no further analysis is mandated. We affirm Nash's conviction and sentence. So let's learn a little bit more about what happened that caused this situation. While confined at Newton County Jail on a misdemeanor charge, Nash asked a jailer for some juice. At first, the jailer thought Nash was asking for something to drink, but then Nash slid across a cell phone that he had on his person. The jailer took the phone and gave it to the sheriff's deputy in charge. Nash later denied the phone was his, but when the sheriff's deputy unlocked the phone, using the code Nash had given the jailer, he found photos of Nash, as well as a text message exchange from the day Nash had handed over the phone. The incoming message asked, WYA, short for where are you, and the outgoing message replied, in jail. On appeal, Nash challenges his sentence only. He argues the 12-year sentence violates the Eighth Amendment of the United States Constitution because it is grossly disproportionate to his crime of possessing a cell phone in jail. Nash begins his proportionality analysis by asking this court to recognize differing degrees of transgression under the relevant statute. The statute provides any offender confined to a correctional facility from possessing any weapon, deadly weapon, unauthorized electronic device, contraband item, or cell phone, or any of its components or accessories to include, but not limited to, a subscriber information module, SIM card, or chargers. What Nash dubs as mere possession of a cell phone is a specified violation of the relevant code, and the statute subjected him to the same potential punishment as any other violation of the code, imprisonment for not less than 3 and not more than 15 years. Now, I do understand Nash's point here. Some of these things don't really feel like the others. To say you can't possess a weapon in jail and you can't possess a cell phone in jail or a SIM card in jail, those don't really quite feel like the same category of thing to me. One is obviously, or at least it seems to me, much worse than another. And so for you to treat them all the same is a little odd. But it is all in the same section. Whether or not it should be or not, it is. And so courts applying the statute simply say, well, it's listed as one of the elements. The statute itself doesn't attempt to delineate one from another. So you're saying, Nash's argument that some of these things are inherently worse and should be treated inherently worse is not borne out by the statutory text. The statutory text treats them all the same, for better or worse. And as we were discussing in our Uber California stream, this is something that state legislatures get to do. They are different things, and so you can treat them the same or treat them differently. I don't think you should treat them the same, but can you? Yeah, there's no obvious reason you can't. And it seems proper, and so therefore the court said, well, this is a proper decision because that's what the legislature wrote, and so we're just going to enforce the laws they wrote it. So that makes sense. There is, however, a very limited and rarely imposed exception to the general rule. The Eighth Amendment, which forbids cruel and unusual punishment, contains a narrow proportionality principle that applies in non-capital cases. However, in the present case, the trial judge did not simply opt for the maximum penalty without justification. Instead, the judge exercised his discretion after reviewing a pre-sentencing investigation report. Similar to a prior case called Ford, the judge emphasized that possession of a cell phone in a correctional facility was a serious charge. And unlike the cases of Davis and Ford, Nash's case showed him as a documented repeat offender. The judge noted that Nash's prior felony convictions subjected him to 15 years imprisonment to be served day for day had the state charged him as a habitual offender. So here the court is saying, well, the court actually looked at all the relevant situations, including his prior conviction status of various things to say what it should be. So it's not that they just gave him the max, they looked to various situations to assign a number. And that's usually a matter of trial court discretion to analyze the facts, and it's not clear error, it's not abuse of discretion, so, the appeal court isn't going to overturn that. So that makes sense too. While obviously harsh, and I would agree with that, it is obviously harsh, Nash's 12-year sentence for possessing a cell phone in a correctional facility is not grossly disproportionate. Now, whether or not you believe that, as a matter of personal opinion or not, I leave to your judgment. Again, for better or worse, the state legislature, when they wrote this law, are treating a gun and a SIM card as the exact same thing. I don't personally think they are the exact same thing. And so to say, if a gun should get 15 years, to say a SIM card should also get 15 years, does seem a little disproportionate to my mind. But is it grossly disproportionate within the meaning of the Constitution? No, it's not. I personally don't think these things should be treated the same, but the state legislature treats them the same. And so, for better or worse, the court is stuck with what the legislature wrote. So what else can you do, really? I'd also like to read a little bit from the concurring opinion of the presiding justice, whose name is King, because he wrote some language in here about some particular concerns that also make this questionable in terms of it. Now, he's concurring, so he's agreeing with the decision, but he wanted to bring a note of some particular things that might be of interest. So let's read what he wrote. First, it is highly probable that the Newton County jail booking procedure was not followed in Nash's case. An officer at the jail testifies that all inmates are searched when booked, although that officer did not book Nash. Yet Nash went into jail with a large smartphone that would have been likely to be impossible to hide during such a search. That officer also testified that inmates were being told during booking they could not bring cell phones into jail. But Nash's behavior was that of a person who did not know this, as he voluntarily showed the officer his phone and asked the officer to charge it for him. This judge named King also says, I note that Nash's criminal behavior and history evidences a change in behavior. Both of his previous convictions were for burglary. His last conviction was in 2001, and he was sentenced to serve 7 years. So for approximately 8 to 10 years, Nash has stayed out of trouble with the law. Combining this fact with the seemingly innocuous, victimless nature of the crime, it seems it would have been prudent for the prosecutor to exercise prosecutorial discretion and decline to prosecute or seek a plea deal. In the same vein, it would have been prudent for the judge to use his judicial discretion in sentencing Nash to a lesser sentence than that of 12 years. Finally concluding, this judge says, Nash did not do anything nefarious with his phone, and he certainly did not hide the phone from law enforcement. While I do not think this court can find under the law that the trial court abused its discretion in sentencing, it is a case which, in my opinion, both the prosecutor and the trial court should have taken a more rehabilitative rather than punitive stance. So that is the end of the case of Willie Nash versus the state of Mississippi. In this case, Mr. Nash, while in jail on a misdemeanor charge, somehow had a cell phone on him, and he asked the guard to charge it for him. Unfortunately, possession of a cell phone in a jail is treated the same as possession of a gun in a jail. Whether or not they should be the same, they are the same, and the state legislature gets to make those choices. They get to make those kind of choices in the Uber case that we discussed earlier, and they get to make those choices now. They are different enough that they could be treated differently. There doesn't seem to be sufficient tie to one that they should be necessarily treated the same, but because they are different, they can also be treated the same if the state legislature wants. It's not so close to something else that's treated differently that it defies rationality. So here, I tend to agree with the concurring opinion of the Judge King. I think that on balance, this is a case that really wanted some more mercy than was applied. But this is an issue of the trial court's discretion. And the trial court gets discretion on sentencing, and the trial court made its decision based on relevant factors. Now, this judge is basically saying, well, I think other factors would have counseled me to go the other way. But he's saying at the same time, I can't decide that the court below was clearly an error or abused discretion. I think that he showed that he lived a good life. But you want to say he's a two-prior felon? That's a reasonable thing to do. So Mr. Nash goes from serving a misdemeanor time to serving 12 years in jail, or in prison, I should say, for something that's arguably not his fault because the phone should have been taken off him and it wasn't. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.